Welcome and thank you for attending. Questions can be asked using the questions pane in the webinar control panel. Today's presentation will be recorded. If you have any objection, you may disconnect at this time. I will now turn the presentation over to your presenter. You may begin.
Good afternoon on 1201 SHRM, Long Island. This is Henry Shapiro. I thank everybody for dialing in on this odd weather of a day right before we start December. Year is winding down. Hopefully people are getting ready for holiday parties. Hopefully people have started harassment training. And hopefully people have some nice vacations lined up, or at least time with the family. So today we are going to, or we being me, is going to bend your ear about a new law passed at a place near and dear to all our hearts, where my office is, Suffolk County. A law that doesn't require you to do too much, but something you want to keep on your radar, something that you will need to adjust for come next June, and something for those of you that are only in Nassau, where you might be thinking, oh, I don't care about Suffolk, it doesn't really pertain to me. This will likely head towards Nassau as well, or to New York State generally. Salary history is something that has become more prevalent and hot lately, especially in the last 2 years with pay equity issues. For those of you that attended last month's webinar, I believe my colleague Dan Duff was speaking about the pay equity, updates in the community. So what we see with salary history is we deal with employers that improperly try to obtain salary information from a applicant that they're looking to hire, and then base what they want, what the employer wants to offer, off of the old salary the employee or the applicant made at an old job. The issue with that, although you might think that there's nothing wrong with that, the issue, and we'll get into it in a little bit more detail, is you end up perpetuating wrongs, arguably. So if there's a pay gap, historically, I'm sure many of you can imagine, females do not get paid the same as their male counterparts, which is obviously incorrect, and it's being worked on to become an issue of the past, but it takes time, and it's not happening overnight, although it should. Also with minorities, Hispanics, African Americans, they also face pay issues when compared to their white counterparts. Unfortunately, it's a realization that's gone on in the employment world for too long of a time. And now New York State, which I'm sure you are not shocked by, is looking into it. I mean, it's not a New York State law, but the city has a law, Westchester has a law, Albany has a law, and now Suffolk has a law. So last week, Suffolk lawmakers passed legislation that would bar employers from asking a job applicant's salary and benefit history during the hiring process. And I kind of just went over it with you as to why this has become such an initiative. And if I was a betting man, which I'm not, but if I was a betting man, I would tell you that Governor Cuomo will get this up in Albany. And when I say up in Albany, Albany has a law. I mean more for the statewide. Suffolk is the only place so far on Long Island to do it. Obviously, there's not many options. It's either Suffolk or Nassau. Nassau has not done it yet. But if it doesn't come this year or next year, it's something that I think you will end up seeing in the New York State budget probably within the next 3 to 5 years, maybe quicker. Especially, I think there's going to be a nationwide initiative for this, especially in the blue states, as we commonly call them, the states that are heavily Democratic. The legislature's focus in Suffolk is on reducing pay inequity for women and minorities. Suffolk, as I said, joins the city and Westchester. Westchester's law is more recent. We'll get into that very quickly, but that's become effective as of July 9th of this year. The New York City law came into effect October 31st of last year. So this is all somewhat of a new topic, but it's something that, it's an easy thing to clean up. It's if you're, doing anything that's now considered unlawful that wasn't previously, but it's just something you want to make sure that you pass down to all of your supervisory team, all of your management team, anybody that could be interviewing, speaking with applicants, because the last thing you want is, somebody to make an innocent mistake that costs you. So let's look back just so you kind of know, we know where we're at right now, but it's good to look at how we got here. And how we got here is New York City was the first one to kind of kick this football off and see what happens. So as I said, October of last year, any public or private employer is now prohibited in New York City, is considered against the law, prohibited from asking an applicant salary history during the hiring process. So some of you might know about the background check process and the Fair Chance Act in New York City, and when you can ask about criminal convictions. That's all after that conditional offer. This is a little bit different. This isn't about a conditional offer, because obviously when you're making a conditional offer, you're offering someone pay. You're telling them how much they're going to make, whether it's an hourly rate, whether it's an annual salary rate. That decision's already been made. The key is how we get to that number, that monetary payment number. So it applies to full and part-time employees. It applies to interns. It applies to independent contractors in New York City. So most positions are covered. What it does not apply to are people who already work for you who are then trying to transfer. So you have somebody in one department transferring to a different department where maybe it's going to be a different pay scale. Where it doesn't apply is if somebody internally is up for they apply for a promotion to a supervisory role. There you have a little bit more. In the city, you have some more leeway. This includes advertisements for positions, on applications, or in interviews. So similar to that ban the box that I was just talking about, the New York City Fair Chance Act, similar to that, where you have to look at everything, your job postings, your want ads, your applications for employment. Same thing here. If you're in the city, you should be wiping away anything that inquires or seeks salary, past salary. If you have something on your application where it says list your employment history for the last 5 or 10 years and what your salary was, that's unlawful. You can't have that. What you are allowed to do is you're allowed to ask for someone's salary expectations. If they say what their expectations are and, you realize that it's never going to work, that might short circuit some of your time that you may waste on interviewing or hiring somebody. Rather than rely on applicants' previous salary, the law aims to have employers and job applicants engaged in salary negotiations focused on the applicant's qualifications and requirements for the job to set a salary. So as you can imagine, I quoted that directly from New York City. I'm not that creative or thoughtful. It paints a very pretty Pleasantville-esque picture of what New York City is looking for. I would venture to guess that doesn't happen very often, especially with some smaller city companies where this is the number that we can offer and this is what this position pays. I don't think there's much in the way of negotiations, but it makes me feel that I should have maybe negotiated my salary to be higher. I didn't, and Chris is lucky for that. So, going into more on the New York City law, what employers cannot do. So I put the cannot first because A, it's typically the longer list as it is here. B, it's usually everything that you think you can do is usually on the cannot do. And C, it encompasses a lot. Ask questions or solicit information about current or prior earnings or benefits. This is in New York City, and this is to an applicant, that somebody is looking to obtain a job with your company. Ask current or former employers or their employees about current or prior earnings. So you can't start calling their old company and say, hey, just tell me how much they make. The old company could technically be in trouble for aiding and abetting a violation of this law, and you would be in trouble as your company for trying to obtain the information this way. Search public records to learn about current or prior earnings or benefits. So you can't start Facebooking, Googling, checking on Instagram if somebody posted their paycheck, which I don't think happens, but who knows. You can't just try to intentionally, unintentionally fall on top of the information, through the internet. I started this one to rely on information about current or prior earnings or benefits to set your compensation. It's if you find out something inadvertently, you're searching for, I don't know. So if somebody tells you when you speak to another employer and they accidentally mention the salary, even though you didn't ask them, you didn't solicit it, you didn't violate the law in any way, shape, or form, but you get that information, or you happen to Google the person's name and it pops up on Google that this is what this person makes, something like that, If it's inadvertent and unintentional, you can't rely on it. So just essentially kind of got to disregard that you even saw it in the first place. I started because if it will, I'll cover this a little bit later. If the applicant tells you his or her salary, they volunteer it when you're, or what they were making at their old job. You know, if you say, how was it working at company ABC? And they say, oh, company ABC was great. They were paying me $50,000. If they volunteer it, then New York City allows you to use that information. The reason, if you think about it fundamentally, is how else, if an employer were to be punished when an employee voluntarily provides the information without any solicitation from the employer or the interviewing employer, how in the world that could be policed, I don't know. Because then every employee or every applicant would just walk into their place of hopeful employment and spew what they used to make, knowing that they just walked this interviewing employer into a violation of the law. So it's almost an impossible thing to police or to enforce. What employers can do, you can make statements about anticipated salary range, bonus, benefits. So you could say, you know, what's your anticipation for this position? You can inquire about their expectations. You could talk about what the position normally pays. You know, I assume it wouldn't be gender or ethnic or racially based on any for any unlawful reason. Now, if the position pays $70,000, this is what this position as an account manager pays, $70,000. And you can inquire with current or past employers regarding non-salary information. So that's your typical, background reference check. You got to do it at a lawful time. You can't do anything criminal background. You got to be careful with credit background. But if you're calling an old employer just to confirm somebody worked there, that's okay. You just can't talk about their salary. So Westchester, as I said, is very similar to New York City. The laws are, have nearly the same provisions. It began as a law on July 9th. What employers cannot do, and you will see this is just Westchester's way of trying to sound somewhat different than New York City, even though it's almost an identical law. You cannot rely upon wage history received from any current or former employer of the individual to determine the wages for such individual. So if somebody slips up and gives you information, not the applicant, you can't rely on it. Same as New York City. If you find something inadvertently, you can't rely on it when determining this person's compensation or salary. If it's voluntarily disclosed by the prospective employee to support a higher wage and offered by the employer, again, that gets to the somewhat similar to the inadvertent disclosure or the voluntary disclosure by the employee or the applicant, his or herself. Require orally or in writing that a prospective employee disclose information about their wages. You can't ask them in writing. It's not just an interview thing. This is an application. This is if they're filling out an application for an interview. This is if it's in a job posting. You can't ask about it. And as you know, under almost every employment law, you can't retaliate. That's in Westchester. So now we get into Suffolk, which you will see is, again, largely mirroring the New York City and Westchester laws. So Steve Bellone, the Suffolk County executive, his quote was, "This law is the first of its kind. It's a first of its kind measure on Long Island that will help shrink the pay gap for women and people of color in the workplace." So we kind of went into that earlier. The motive here is very clear. There's no dispute about why this is occurring. This is not happening because white males are struggling in the workplace. This is to help bring women up to a 100% equal pay for men that do the same work. It's a same pay, same work. That is what the standard is going towards. That's what it should have always been, but it's, again, for reasons that are beyond, I think, everybody on this call, and due to Washington and New York State, it's unfortunately this is the way it's gone. And I think finally trying to fix it is the right move. Just to give you some stats to show you, unfortunately what women and minorities face. Women in Suffolk County make 78.1% of what their male counterparts make, compared with an 86.8% statewide average. African American women earn 64.4%, and Latino or Hispanic women earn 55.3%. So just to give you the information on the name of this actual law, it's the Restrict Information Regarding Salary and Earnings, or RISE Act. And as I said earlier, it goes into effect June 30th of 2019. So now's a good time to get ready and review your applications, review your hiring documents. You don't need to do anything just yet as far as compliance because this law won't take effect for another 7 or so months. But now's the time to start thinking about it. I know a lot of you are sick and tired of hearing me talk about paid family leave, and I tried to set this alarms off for almost 10 or so months prior to the actual enactment of the law. This is the same issue. Just get ahead of it. Don't be rushing on June 29th to clean up all of your applications. Either review them yourselves, have your counsel review them, just make sure somebody takes a look at them. The law itself, for any of you that actually like to read what the statute says, it's, again, parallel and mirroring New York City. Any employer that is considered an unlawful practice for any employer that inquires into a job applicant's wage or salary history, including but not limited to compensation and benefits. To inquire means asking an applicant or former employer orally or in writing or otherwise to conduct a search of publicly available records or reports, very similar to what I just read to you for New York City. I started this one again. So Suffolk County specifically says the law also prohibits any employer on relying on the salary history of an applicant for employment in determining the wage or salary amount for such applicant at any stage in the employment process, including the offer or contract. So the reason I started this one is because New York City their FAQs on their website are very explicit that if the employee or the applicant, I should say, voluntarily provides his or her salary information, you can rely on it. Suffolk is not that clear. Again, for the reasons I said earlier, I don't believe this is something that Suffolk County or any governing body could ever enforce because you're just going to have applicants who don't know the law. They're not lawyers. They're not HR professionals who just walk in and say their salary. And if they now want to bring a claim because of what they said, try having an employer disprove that they didn't rely on it. I mean, it's very hard to do, and I cannot see this being enforced to the detriment of an employer, such that if the employee voluntarily divulges his or her salary, that the employer is now in trouble for the applicant's mess up. There's exemptions for certain laws that require disclosure of an applicant's salary or past salary, and as with most laws, there's an exception for anybody under a CBA. So it's something though that you would have to you should. If you're under a CBA, it's something probably worth discussing with the union just to make sure you don't walk yourself into an unfair labor practice charge when you're only trying to do the right thing. So are you covered? Suffolk County adopts the definition of employer from the New York Executive Law, which codifies the New York State Human Rights Law, which we all know and love. Anybody with 4 or more employees. So if you're a tried and true mom and pop shop and you have 3 or less, you're okay. You don't have to follow anything that I just said, and I apologize for wasting your time, but it's still good to know, because who knows if New York State ends up making a law saying that all employers have to comply with this. It wouldn't be the first time. Reference paid family leave. 4 or more employee requirement, and if you're not in Suffolk, be vigilant. New York State, as we all know, went Democratic in the last election 3.5 weeks ago at this point. It would not shock me for Governor Cuomo to pass some kind of statewide salary history law. When it happens, I'll tell you I told you so. If it doesn't, I'll say I never said this. So you're never going to get me on this although I know this is being recorded. But Nassau County likely will also come shortly thereafter because Suffolk and Nassau usually follow somewhat hand in hand, especially with the city, because right now Suffolk and New York City are looking at Nassau, and Nassau is out, on the outskirts looking in, saying, "What's everybody else doing?" Penalties. This is just to scare you as we end. There's possible compensatory damages. There's possible fines and penalties. New York City also has a mandated training and posting requirement if you violate the law. That could happen. It's not affirmative, but it could happen. Suffolk doesn't speak to that, but again, don't be shocked if they end up adopting something or amending it to have something similar to New York City. So your best practices, and I'll let you all sign off with this one, is review all your job postings, your applications, your hiring materials, your policies, just the same for those of you who have operations in New York City, where you reviewed everything for the ban the box to making sure we don't have anything that says, do you have a criminal conviction history, or are you are you available to conduct a background check? We took all that off if you have operations in New York City. If New York State ever passes a similar law, it's going to come out everywhere on Long Island too. It's the best practice just to get rid of it and get ahead of the curve. Same here. Even if you're only in Nassau, get rid of anything where you're asking about someone's past salary. Look, especially where we see it is in the employment history box, where you have employers that ask, what was your salary? Salary when starting, salary when leaving at your old jobs. Get rid of those. Review with your personnel. This might be the most important one. Whoever's doing your interviewing or dealing with anything with applicants, make sure they know. Avoid salary discussions regarding past salary history. Avoid it at all costs. It's not worth the trouble. And the last bullet point is exactly what I was saying to you earlier. In New York City, it's very clear, according to them, according to their FAQs on their website, if the applicant voluntarily discloses his or her salary information, the employer may then consider and verify about the applicant's salary history, verify the applicant's representations about salary history, and rely on information about the applicant's salary history in determining what to offer the applicant in salary, benefits, and other compensation. So again, if the employee or the applicant at that stage says something and volunteers it without you soliciting it, it might not be a terrible idea to make a note of that just to prevent against any claims. We all know the document adage that we all preach, but it's definitely a best practice to take that up. So I thank everybody for joining. Sorry for running a little bit over time. Have a wonderful weekend, and we hope to have a session in December. We're going to confirm that with the holidays, but I hope everybody has a wonderful weekend and enjoys the holidays if I don't speak to you. Take care.